joining this lecture. So my name is James Aaporekuu. I'm a member of the Chartered Institute of Arbitrators, London, an LL.B holder, and also the Vice President of Administration African Law Student Association. I'm actually Ghanaian, but I'm based in Rwanda. So that is all about me. So today's lecture is on mediation. All right. So when we say mediation, what at all does it entail? Before we can say that we are going to mediation, it means that there might have been a conflict, all right, that between two or more persons that they have been unable to resolve, and to that extent, they want a third party, impartial indeed, to intervene to resolve that particular issue between them. So first of all, before we can say that we are going to mediation, we are going to mediation, there's always a conflict that needs to be resolved. So we have life differences, we have individual differences, we have like background differences, and these differences amount to conflicts whenever people are unable to compromise amongst themselves. So unresolved differences, leads to disagreements, and disagreements is a cause of a problem. And once the problem is resolved, parties resort to a dispute resolution. So that is the mediation. Mediation per se is one of the components of ADR, that's alternative dispute resolution. All right. So mediation, when we talk about mediation, is just basically a situation where parties submit their dispute or disagreement to a third party to assist them, to come to an agreement amongst themselves. So it is an assisted negotiation kind of. So when we say negotiation, mediation is negotiation per se. Once you say negotiation, it means that you're going to buy, for instance, Nigeria jollof or Ghana jollof. Let me use this way. All right. And the seller is saying that I'm selling for you at 20,000 naira or 20,000 Ghana cedis, and you are trying to negotiate. The negotiation is a direct negotiation between you and the seller. So once it goes beyond that, all right, to a third party, it becomes a mediation because the third party comes in to assist the both of you to reach an agreement. So mediation is also a form of a negotiation, but not a direct negotiation. Negotiations through a third party who is impartial and to help the parties resolve an issue. So what then is mediation? We are saying that mediation is a voluntary, party-centered, and structured negotiation process where neutral third party assists the parties, as I've already said, assists the parties to amicably resolve their differences or their disputes through a specialized communication and negotiation techniques. So this one, the parties have control over what will be discussed or the method to be invoked in the resolution of the problem during mediation processes. So that is one of the flexibility when it comes to mediation process as compared to the court system where the court sits somewhere and decides for the parties. You can go to the court, all right, at the end of the day, there will be a decision, but the differences between the parties may not be resolved per se. And that is why most at times people go to court, they are unsatisfied, they have to appeal to the next hierarchy of the court and what have you, because they are not satisfied. But with mediation, it's a win-win situation. All right, parties move out from the mediation room with their problems resolved. They all understand each other that this is what we want, not what somebody sits somewhere and impose on us. So moving on, what are the mediation stages that we have? We have 4 basic mediation stages. All right. When we talk about mediation, all right, the basic and the principal ways and means of negotiating is through this means that I've highlighted over here. That's the functional stages. So we call that the introduction and opening statement. All right. So when we talk about introduction and opening statement, is where the mediator. So we have mediators who are certified mediators through a lot of organizations. All right, who are also very worldwide known that this is what they do. They give you that status as a mediator. So the mediators, most associations or in most countries, they also have the association. Once you want a third party or a person to mediate on your issue, you approach them and it is resolved. So once you approach a professional mediator and he or she intends to assist you in resolving a dispute, these are the basic stages that must go through. First of all, introduction and opening statement. And at this stage, the mediator introduces himself or herself to the parties before him, and then tell the parties, all right, what you are supposed to do at stage A, B, C, D. You tell them I'm a mediator. I've been a mediator for 10 years or 5 years or 2 years, and then I've done A, B, C, D. Once you've approached me, this is my office. All right. If you want to use the washroom, you go to your left, go to your, and then you ask for the parties to also introduce themselves. And an opening statement basically has to do with the lay down rules and procedures that is involved in the mediation process, where you have to tell people or the parties before you that when one party is on the stage speaking, you need not to interfere. When that other party finishes and you have something to say, I'm going to give you that opportunity to also express your opinion, because that is basically why the both of you are there, for him to assist you to negotiate. So this is basically the opening statement, is basically the ground rules. The introduction is where the mediator introduces him or herself, and then any place, for instance, if you want to drink water, if you want to do it, you can have a break, ask for a break. All these things are stated in stage one. So stage two has to do with understanding the parties and their issues. So first of all, once you've introduced yourself and laid down the ground rules, you have to understand the parties. Why are they before you? What is their issue? And then understand the parties and their issue. That is where you now try to propose, all right, and tell the parties that, having narrated your story, okay, what does party B also have to say? Party A have said A, B, C, D. Now you, the mediator, you're now privy to the core issue, the underlying issue that is between them. You ask party B, the party also identifies this or a problem. Then you now get the issues. Once you get the issues, you now ask the parties, and that will be the next stage, stage three, the problem solving stage. The problem solving stage is where you ask the parties to brainstorm. So having listed their issue, their problems amongst them, you ask them, what do they think, is the best way to resolve this problem that you've come before me for me to assist you to resolve. So over here, you, the mediator, the principle is that you don't propose from the word go. Once you propose, you have an upper hand over the parties. They're going to say what we say instead of them brainstorming that let's do A, B, C, D. So you allow the parties themselves to say that I want A, B, C, D. One will say that I want this. If it's a divorce case, one will say that yes, I want my husband to do this. If it's a divorce case, one will say that to give me 90% of the properties that I'll give you. There you see some compromise, let them see them. So for instance, don't you think that if the properties are shared 50-50, it will help the both of you ABCD? Then once they brainstorm, we now try to come in with any other subsidiary um solutions, or how to take approach as far as your case is concerned. Um, okay. Yeah, so the last stage is also the closing stage, where once they've been able to compromise or come to an agreement amongst themselves, they agree that this agreement that we've come into, it must be enforced within this stipulated time. Once it fails, we are going to come back to mediation, or we are going to court for enforcement. All right. So over here depends on the parties, what they agree upon. And at the end of the day, all the parties in the mediation process are going to sign, okay, this particular agreement. Once they reach an agreement, they sign. Once they don't reach an agreement, there is no signing. It is deemed that nothing was done, so the parties go their way. But once they reach an agreement, the parties sign, and then the mediator also sign to attest that they appear before him or her for an assistant to resolve an issue. Now, what are the types of mediation that we have? We have basically two types of mediation, and I highlighted them here. So the first one is the court preferred mediation. So basically, there are instances where a case may be in court. The court will direct that let's direct this cause, or let's refer this case, all right, to a mediator to resolve the issue. The court so more to can do that, or the parties to the case can ask the court that at this stage, you want the mediator to assist us resolve the issue instead of you resolving the issue in court. All right, so that is the court referred to. So over here, the court now make the referral to a mediator to resolve the issue. One thing you should be noted over here is that once the issue is referred to a mediator from a court, and then it is resolved the court as if it was a court decision, and then it becomes binding on the parties. All right, so that is one aspect of it. The private mediation, in private mediation, qualified mediators offer their services on a private services. For instance, once the members of a public or someone approaches a public mediator, over there, you are not referred by anyone. It's the both of you who prefer to go to such a particular mediator to assist you to negotiate or to come to an agreement. So that is how that one also is done. So these are the differences between private mediation and public mediation. So at this juncture, it is supposed that the types of mediation, it's very well known here. And if there's any question in the process, please ask so that I'll clarify issues before I get to the conclusion of this lecture. What are the features of mediation? So the features, you say that mediation is voluntary. Why is it voluntary? It is voluntary to the extent that the parties, they agree amongst themselves that they want to go to mediation. Okay, they are not imposed, unlike arbitration, which is one aspect of ADR also as well. Arbitration, to some extent, we will say it is voluntary, but not absolutely voluntary, because at the end of the day, there is a mediator or like an arbitrator who imposes an award on the parties. All right, but over here, the parties themselves, they are in control whatsoever thing happens during the mediation process. So it is voluntary. The parties have control over the processes. Secondly, we say mediation is a party-centered negotiation process. So the parties and not the neutral mediator are the focal point of the mediation process. Only the parties play the key role in the mediation process. So as a party-centered mediation process, negotiation process, the parties decide the processes, okay? They decide that ABCD, want ABCD to be done. This is their case. You, the mediator, you don't have any absolute power over the parties. What they say is what you guide them to arrive at. So that is why we are saying that it is a party-centered negotiation process. And thirdly, we are saying that mediation is a structured negotiation process. All right. Though the mediation process is informal, which means that it is not governed by any rules of evidence and formal rules of procedure. It is not a casual process. So we are saying that the parties, they decide the process. It is a structured negotiation process. What the parties agreed upon is what is going to be adhered to by the mediator. So the mediation process itself is structured and formalized with clearly identifiable stages. So these stages can also go back to the four stages that I've already iterated, mentioned during my earlier stages of this presentation. So it continues. Mediation, in essence, is an assisted negotiation process, as I've already said. Once negotiation is between one and the other person, so that we say direct, when we say negotiation, direct negotiation, seller buyer, that's direct negotiation. But once it goes beyond that, it becomes an assisted negotiation in the sense that there's somebody intervening between you, the buyer, and the seller. So that is why we are saying that it is an assisted negotiation process. And the next feature is that mediation is conducted by a neutral third party, that is the mediator. So mediation is conducted by the neutral third party who serves as a mediator. The mediator, you don't have any power to make decision for the parties. You are independent, detached, and objective throughout the mediation process. Okay, so your work as a mediator, your basic role is to just facilitate and evaluate the process, the mediation process. You don't have any decision-making power. All right, it is only the parties that have that. You just have to guide the parties to get to that decision-making stage. But you as a mediator, okay, you are just there to assist them, to facilitate the process and evaluate, assist them to reach a conclusion. So the next one also is that, mediation is a private process. It is not open to a public, unlike the court system, where if you decide to go to court, All right, everybody in the court system know that no, this person have instituted a case against ABCD, or this husband is trying, Mr. A husband is trying to divorce her. No, in the mediation process, it's not a public one. It's not open to the public. So it is between the parties themselves who are having issues and the mediator. Unlike the courts, once you go to the court, your case is open. Even the newspapers will take it. Even the worst aspect of it is that when you are a celebrity or if you are well known in society, it becomes news. Newspapers take it and publish all those kind of things. In mediation, it's a very simple process and a very private one, unlike the court system. So what are the disadvantages and advantages of mediation? So these are the advantages. All right. Mediation offers the following advantages. So the parties have control over the mediation in terms of its scope, okay, and its outcome. How the scope is, so the terms of reference and the issues, they determine the issues. At the end of the day, they raise their issues and determine it, and they can expand it during the course of the proceedings. Okay, and they also, once they do that, they determine the outcome of the mediation process. Okay, so mediation is participative. Mediation is participative because the parties during the mediation stage can say whatsoever thing they want. They can express their everything. That's why mediation process, some of the parties can even be crying and all those kind of things. We are saying that it's participative because you are not restricted from saying certain things. Unlike if you go to the court restricts you. Don't say this, don't say this, say ABCD, say ABCD. In the mediation process, it is not done that way. It is participative because all the parties can say whatever thing they say. They have the opportunity to present their case in their own way, directly participate in the mediation process. So the process is voluntary. Any party can opt out of it at any stage if it feels that it is not going to help. Yes. So the volatility of this process extends to the extent that, once you go to mediation and you think that the process is no longer going well, the mediator is not doing as anticipated, you can work out of the mediation process. So that is one aspect of it. All right. So it is voluntary. The procedure is speedy, efficient, and economical. There's no much money to waste when you go to mediation, okay, to make peace with someone at a mediation stage. Mediation is just like the court, going to court, but these are some of the advantages over the court system. And most of the time, people resort to mediation. Okay, a good lawyer is the one who always try to resolve the case outside them before even going to the court in the first place. So most of the time, you see the lawyers at the law firm resorting to alternative dispute resolution mechanism, just like the mediation. Okay, before once it fails, they now intend to go to court because this is the same way as the court system and more flexible, speedy, and economical. I don't waste much money. It is simple also as well. It can be modified to suit the demands of each party and not being imposed by the court. Okay, the process is conducted in an informal, cordial, and conducive environment. Once we say it is informal, it doesn't necessarily mean that anything can be said over there. It's informal to the extent that if it is compared to the court system, the way the court system is structured, um, the way the court system is structured, because once you want to institute a case, all right, you have to go through the procedure to institute a summons and all those kind of things. In mediation, you don't have that, but it's cordial and conducive way to assist or to help both parties. So it is a fair practice. The mediator is impartial, neutral, and independent. The mediator ensures that the pre-existing unequal relationship, if any, between the parties do not affect the mediation process or the negotiation. So, as I've already said, this mediation process is also confidential. It is not open to everyone. It's a confidential information between the parties. The demerit of mediation, or one of the disadvantages of mediation, is that it is not compulsory. It's not compulsory. What does it mean? It's not compulsory in the sense that once you say one party A wants to go to mediation, and party B can also disagree that I don't want mediation, I want arbitration, I want us to go to court, or I want conciliation. So it is not compulsory to the extent. These are some of the disadvantages. You may want mediation, the other party may not want mediation. So it also leads on to some back and forth of the processes or the dispute or the differences between the parties that they want to resolve. Secondly, concerns exist around the enforceability of mediation agreements. When it comes to the enforceability, once there is a decision, the enforceability is very key. If a decision that cannot be enforced, then that decision is useless. So once the mediator comes to an agreement, okay, with the parties before him or her, and it is unable to be enforced, it becomes a very huge problem among the parties who even appeared before the mediator for such an assistance. So all parties must agree to a resolution as the result is not guaranteed. So over here, the parties before the mediator are agreeing to A, B, C, D, but who is it guaranteed that at the end of the day they are going to adhere to what they are agreeing to? It can be difficult if either party are withholding information. So one of the basic thing in mediation is that it got to a stage where all the parties or the parties, one of them is not trying to come forth with some information, critical information that will assist or that will help the mediator to assist them to reach a conclusion. If it happens this way, it becomes so difficult for the mediator to assist them and they may go out without resolving the differences between them. These are some of the disadvantages. And that is why during the mediation stage, we have something called the caucus room. Right, the caucus room per se is when some information are hidden. You think that there's much need. You call one of the parties to a secret room and start to ask a lot of critical questions to get more information, or when you think they are withholding some information. Once you do that, you have to do the same to the other party that you didn't tell, because if you don't do that, it's going to raise some sort of bias towards the other party. So mediation may not be appropriate if one of the parties required public disclosure. So you think that mediation is a secrecy, is a confidential process. So if any of the parties to the mediation requires public disclosure, it becomes very difficult for you to go to mediation because mediation is not like the court system. So these are some of the disadvantages that comes out when it comes to mediation. I think because of the time, I'll have to skip this. But these are the basic and the obvious disadvantages that we can talk about. So during the mediation process, either party can withdraw from the process at any time. There is no possibility that the information may be given away to the other party during the mediation process that could benefit the other party. So these are some of these things. When it comes to the comparison, you have to compare between mediation and the court system, because sometimes people want to say, why should I go to mediation if I can go to court for the judge to do A, B, C, D? How different is the mediation process from? So now, in the judicial process, it is a judicatory process where a third party. So as I've said already said, when you go to the court, a third party is sitting somewhere called the judge with a lot of authority who decides the outcome of the case. When you go to mediation, no, that is not the case. The party determines their own outcome of the case. It is the mediation the mediation process is not an adjudicatory process in the sense that the mediator only facilitates and evaluates the parties concerned and assists them to reach a solution. All right. That if you go to court, you don't get that opportunity. Your decision is being imposed on you. Secondly, procedure and decisions are governed, restricted, and controlled by the provisions of the relevant status. So as I said, procedural grounds, once you go to court without following a due procedure, your case is being annulled or being discontinued. By mediation, the procedure is and settlements are not controlled or governed or restricted by any statutory provision. When it says statutory provisions, there are laws, okay, that have been passed by Parliament to regulate a certain procedure when you're going to court. But in mediation, we don't have such laws. So that's why it's very flexible, conducive, and what have you. Thirdly, the decision is binding on the parties. When you go to court, okay, the court decision is binding on the parties. All right. By decision, settlement is reached only if parties arrive at a mutually acceptable agreement. So over here, the mediation, once they reach a mutually acceptable agreement, it now becomes binding. But the court can reach a binding decision without it being mutually acceptable by all the parties before the court. So these are some of the comparisons when it comes to mediation and the court system. Fourthly, adversarial in nature as focus is on past events. So this one, I say adversarial because the judge sits somewhere and adverse is just a kind of putting it to somebody, say this for liability of the parties. But in collaboration in nature as focus is on the present and the future, the resolution of dispute is by mutual agreement. So this in this one, somebody's just sitting there putting it to you, I put it to you, ABCD, ABCD, you've done ABCD. In mediation, you don't have that process. The mediator don't have that opportunity to do that. That's why I say that it's party-centered. So fifth, personal appearance or active participation of parties is not always required. In in mediation, the party's appearance is most not required. A lawyer can appear before you or something like that. But in court, personal appearance and active participation of the parties is required of everyone. Okay, so a formal procedure held in public and follows strict procedural stage. In court, there are procedural stage you have to follow. Once you refuse to do that, it creates a lot of disadvantage to your case. So a non-judicial and informal procedure held in private. So with the mediation, it is a non-judicial and informal procedure that is held privately between the parties. So decision is appealable, settlement is final, and is not appealable. So in the mediation process, they are saying that settlement is final and not appealable. But when you go to the court, people can continue to appeal. They appeal till they go to the Supreme Court. So and it comes with a lot of cost, and it's not economical. So having said all this, and boiling down to the last slide, last but one, they say, what then are the essence of mediation? What is the importance of mediation? Having said all this, draw the differences and define what mediation is and define what amounts to mediation and defines all the stages of mediation. What are the essence of this mediation that we are talking about? First of all, we are saying that mediation resolves disputes quickly before they result in legal actions. So I've already said, a good lawyer is the one who always tries to invoke mediation ADR processes before going to the court, because once you've been able to do that, you still earn that amount of money you will have earned with as going to court to waste a lot of time. So mediation helps resolve quickly a problem between parties, and either to prevent illegal actions. So secondly, resolve dispute inexpensively. So once you go to mediation, it is very low. There's no cost. There's not so much cost in mediation. Even though the mediator is going to charge, but it's even between you, the parties, to agree that I'll pay this percentage of the service that is rendered by the mediator. ABC, then you are going your way, but with the court, you have to buy fuel for the lawyer, you have to pay consultation fee before you go to the lawyer, to the law firm, all those kind of things. It's very expensive. Litigation is very expensive. Thirdly, maintain personal and or professional relationship. Most of the times people have the notion that once party A sues party B, or once Kaleche or once Amalache sues Kofi, they become enemies automatically. So once you go to mediation, it still maintains that personal and professional relationship that existed between the parties prior to that particular dispute between them. But once you go to court, automatically, they become enemies to each other, and that is not a good way to go. So mediation is always the best way to maintain peace, okay, between people or between persons that are around us. Last but not the least, resolve dispute with more satisfying result than what a court may order. So once you go to mediation, the parties that are centered, they play a major role in the outcome of the decision. So they go in a win-win situation, unlike going to the court, where the court will say that, yes, having looked at the evidences that I've put before this court, I think that the plaintiff was correct on the balance of probabilities. No. And the other day, the defendant will say that no, I disagree with the court, or they are going to appeal to the court of appeal or any other court, depending on where you initiated the case. Over here, it's not satisfying. The court may reach a decision, but it may not satisfy all the parties before the court. There are situations where the court even reach a decision, and both parties to the case, both the plaintiff and the defendant, will still appeal on that decision. That means that the court decision is not always satisfying. They always make an order depending on what the law says, but not satisfying the needs of the parties. So that is one major essence of mediation. In mediation, this is not there. All the parties are satisfied once the decision is reached. Lastly, active participation in solving their own conflict. So in mediation, the parties participate actively in resolving their own dispute. Instead of the court restricting, if you go to the court restricts you. You can't say this, you can't do this, you can't do this. No, in mediation is the opposite. Parties play a very major role, and they participate in the reaching of a solution, okay, in resolving that particular dispute amongst them. So at this juncture, my dear comrades, this is where I can say, or we've come to an end of this recap lecture, and I'm open to questions, if any. Thank you so much for your time.
Thank you, Mr. James. It's been a good one. Thank you for your patience, and thank you for agreeing to do this. I hope that if we do call on you again, I'm pretty sure that you're going to, respond to us. And so my question is, can you hear me?
Yes, please, I can hear you.
Yeah, so my question is, now in the case of, well, I will come to dance mediation, which is what we're trying to do. But in the case of issues that have to do with countries who have, in Nigeria, for example, there is the issue of border clashes, between Nigeria and Cameroon, and some other border issues like that. And most of these issues, because of the fact that most of these countries are cohabited together as a matter of sharing boundaries, all these things now fall into diplomatic ties, whether there is diplomatic ties or not. But in this issue, what do you think that mediation can? How do you think that mediation can be effective in the areas where we have border clashes that has to do with, first, before government presence get there, how do you think that mediation can help? That's my question.
Okay. Thank you so much, sir, for that particular question. Yes, to begin with, when it comes to international issues like this, we have pacts, or in other words, you have international treaties that regulate that or those particular issues. And when it comes to mediation too as well, in mediation, is not, you can't say that it's subject to all cases that happens. These border clashes that you're talking about, is it as a result of most of the times terrorism? Is it like out of war? If it is anything that has to do with criminal issue, you say criminal matters, they are being handled by the state agencies, they are handled by the state. When it comes to criminal issues, it's in the hands of the state handles those issues. And even in the absence of that, once there's a treaty, it's a country to country, they can still mediate, but it depends on the status of that particular case. If it has any elements of crime, it automatically will prevent the parties from going to mediation, because over there the state is going to step in immediately. I getting it. However, if the pact or the international treaty that's between country A and B, like Nigeria and Cameroon, if it states that once there is a clash between these countries, the first step we need to do is to resolve it through mediation. Then if it fails, we go to litigation. Then the mediation becomes the prerequisite or a requisite condition to go into court. So once the mediation fails, then the courts will order them to go to negotiate before they come to the court system. So that is how it is done. It depends on what the treaty says. And having said that, if it's a criminal matter, the state steps in immediately and prevent from going to mediation. Thank you.
Yeah, thank you. I think that mostly answered the question. The reason why I think I make that because in some cases I can cite like two cases that are very similar to what we are talking about. And first is the issue of the farmers and the herders clash. And if you look at this issue first, like why I talked about the border clashes is that in most of these areas, government is far from the people, because most of that area is outside most of the region, because it's like a border region, so most of the people are not, before you get government presence, it's usually between the community elders and people. So when it gets out of hand, it's where I'm really looking out, before government even steps into now begin to say, okay, these are criminal charges, and I think some cases like is really not working fine because of lack of government presence. Another case that I would like to cite, of course, is there's a case in Lagos State that has to do with some residents and the owner of the actual landowners. All right. And then what happened was that there is a judgment. There is a landmass. There is a landmass which the government intended to use for I think a national hospital at the time that they did First Act 77. All right. So government acquired this part of land, and then when First Act 77 came, government did not use the land, for that purpose. So after some years, there was a coup. The coup came, and then the military government, they didn't do anything with the land. Then again, another civilian government came. During this civilian government period, because of their self-aggrandizement and personal selfishness, they now shared this land. They sold this land to amongst themselves. Don't forget that this land originally belongs to a particular family. Now they shared this land, and then after then, that government at that time, went away, and then the family, the real owner, began a case with the government. And then when they got to the Supreme Court, there was judgment from the Supreme Court that the Lagos State government should, return the land to the landowners, because it was, you didn't use it for. But now this land, this space I'm talking to you about now is one of the most reserved community in Lagos, one of the richest community in Lagos. And then it's not easy for the people who are the occupant of that land, to now say that they want to leave. So they have been on this negotiation. Now what happened? The governor now came, okay, after the Supreme Court judgment, government, the Attorney General of the Federation now instructed the Inspector General of the Federation, to give the family of the landowners, all the support, all the resources they need, to get back what rightfully belongs to them. And don't forget that, because of government politics and their antics, the government that sold the land that time, one of their footage is also the governor of the present time. I hope you understand my. So in this case, although the governor, when these people came, when the people from the police, from the federal government came, they sealed the entrance to that estate. It has become a very big estate. In fact, one of the most expensive estates you could think of in Nigeria. So during this seal, the the governor came, and there was like a face-off between the governor and what's it called? The, the the people who came from Abuja. So what do you think mediation can, if you understand my question, what do you think mediation, I see the governor trying to play that mediation, in that process, trying to make the family of, trying to intervene in the issue, but I think that, because they are further of the same bed, do you think that mediation can work in this regard? These are very technical issues. So I need uh, your reaction towards that.
Okay. So if I understand the question properly, it means that the state, per the narrative that you're giving, it means there is a government that have a seal with the residents in that particular area, all right,
Right,
and trying to intervene with the usage of that same place, a different government or the same government trying to intervene with the seal that it
right,
has with the people.
right,
Is it the
right.
same
That's right.
government or a different one?
It's the same government.
The same government, okay.
Yeah.
Okay now, but he has offered the resident some initial, how do I say, some benefits. Has he offered them some benefits, or he's trying to just offer them some benefit in order to use the place?
Now, the Supreme Court judgment is that they should get their land back. But when the state government filed an appeal, they now offered the land at the family. Yeah, that's true. They offered the family, I think about 570 something, plots in the estate of any place of their choice. But because of the dynamics of what's involved, there's been a building, people are already living there. There's a question of asking the occupant to leave after so many investment that's bulldozing the place will really not make any and then the real landowners are being deprived of the the judgment of the Supreme Court. So these are
Okay.
two different issues.
Okay, now, all right. So to begin with, I think what I can only say so far this case is concerned is that, first of all, when it comes to the state's power, the states, even almost all jurisdictions, they have the power to acquire land compulsorily. Okay,
Right.
they have the power to acquire land compulsorily. But once you acquire land compulsorily from your citizens or your subjects, you have to compensate them. Okay, so in this circumstance, if at first instance, you, the state, you granted the right of these citizens or this subject of yours to use a particular piece of land for some period, and later on you deem it appropriate to reacquire it or to get it back for any public use, yes, then if it is made clear that it is for public use, then they are entitled to a benefit and investment that have been incurred in developing the said land for the said period that they enjoyed that benefit that you, the state, gave to them. But in the absence of that, if it is being acquired in a political way without any justification whatsoever, then the negotiation also be that, okay, if negotiation fails, if the state fails to provide them with what the individuals want, okay, then that means the state in its first place is failing to negotiate with the people, okay, in order to fulfill their benefit because they've invested a lot of money, a much of money in developing that particular area. So if the state fails to do ABCD for the people, for failing to justify why they want the land back, regardless of the court decision, then it means the government is not willing to negotiate or to adhere to what the people want. Then it will go beyond the mediation, then to the stage where parties or the community will start to institute legal action for that same particular issue. That is how I see it. I hope I get the scenario correct, but that is how I see it to be addressed.
Makes sense. Makes sense. Makes sense.
Yeah.
I don't know if there's any other question from anybody. Okay. In the absence of that, Mr. James, thank you once again. And like I told you, um, Thursday, especially in Lagos, is always dicey for people because it's like a half day for people. So the time, I think that is the timing, I think. But be that as it may, we will not stop here, because I want you to understand that we have to, um, we have to ride on this relationship and make sure that we are just starting. And I know what it is for the average artist, to embrace what is when it comes to embrace things like this, especially when it comes to law, legal, and justice. So, and these are the areas that I think that we really want to have influence and or impact in the lives of all these dancers. So, Mr. James, I'm also reaffirming to you that we will, if you may, we can also institute this discussion further on our collaboration, because we are trying to make sure that we have the convergence of, just like you have with the African Law Student Association. We're also trying to have like a continental a convergence of artist heads of guilds, heads of professional bodies in the African continent. So, and I'm quite sure that our relationship will also make us fulfill this potential. I don't know if, on the last note, if there's anything you'd like to tell us, Mr. James, before we call it a day, because I see that you are already exceeding your time of the time you've given to us, Mr. James.
Yeah, I've exceeded extremely, but I've heard all that you've said. I'm also most grateful for the opportunity offered me. It's a pleasure to meet all of you here, Mr. Hamzat Virus. The Virus, is it your real name or you just added to it? Okay. All right. So I'm most grateful, Mr. Hamzat, yeah, Mr. Oyeniyi, I hope I get it correct. And then Madam Modupe, I'm most grateful for the ample opportunity offered to me. Yes, time is fast spent, but as you've already said, we would like to dwell on the tangent of relationship we've already established. So I will always be available for any subsequent discussions so far as this particular subject matter is concerned for the proper development of peace in our continent, on our continent. So thank you so much, sir. I don't have any other thing to say for now, but what I can say is that I do appreciate your time and everything too as well. Thank you.
Right. Thank you, Mr. James, and I will get back. I'll keep in touch with you for sure. And I hope that we can get this recording after this.
Yes, I'll make it available. I'll make it available.
Perfect. Thank you, Mr. James, and I hope that you have a wonderful afternoon.
Sure. Thank you. Have a good day ahead. Bye.
Yeah, bye.